Hello landlords, it's Ernie, I'm back, and today we're talking all about your tenant. You filed an eviction appeal, but your tenant has actually moved out early. What do you do? Let's get started. As you know, our primary intent is to bring content to you that helps you protect your most valuable asset. You can come to this channel every week for new content. If you enjoy what you see here, give us a like. And if you haven't subscribed yet, please consider subscribing. This week we're talking all about your tenant. You filed an eviction, but they've moved out before the eviction trial. How should you treat that situation? I'm going to give you some tips today. In the past, how have you treated this situation? When your tenant has vacated the property after you filed an eviction, have you proceeded? Have you simply let things go? If so, you may have left some things on the table that you had access to, and you might think next time of doing it a different way. Share in the comments below what your experience has been with a tenant moving out after you filed an eviction but before the trial ever happens. I'd like to know. So naturally, you filed an eviction and your biggest concern is typically, do I have access to my property? Most landlords are perfectly content to recover their property and simply let the matter go. If you filed an eviction and you're set for a specific trial date and the tenant has moved out prior to that trial date, you can forget showing up. The matter will simply be dismissed. The case will be wrapped up and you don't have to think about the lawsuit anymore after that date. However, is that what you should do? Well, I want to talk to you first and foremost about what the law allows. If the tenant was still on the premises after you filed the lawsuit, you're still entitled to recover a judgment. Now, you may think, Ernie, this judgment is totally worthless to me. I don't want it. I don't care about it. I don't want to spend another minute thinking about this case. Fine. However, you may ultimately want a judgment against this tenant for a couple of reasons. Number one, you want to get your money back. And so by having a judgment, you're the most likely to recover unpaid rent from a tenant who owes you for multiple months. Now, you may not be able to recover that rent right from the start, but you may find that through a process of abstract and through certain writs that you can get, that you are in the future eligible to collect this money from, certain property that they own or accounts that they hold. You'll want to abstract this judgment and seek collection if you have a reasonable expectation that you can recover this unpaid rent. And so it might make sense, even though they've left, that you go through, get your judgment, and make sure that a judge has signed off on the amounts that are owed in unpaid rent. The second reason for moving forward with your judgment is to put other landlords on notice that this is simply a bad tenant. You may want a record that this particular tenant simply does not pay their rent on time or went months without paying rent, and you want the world to know it. By seeking the judgment and getting a final judgment for unpaid rent, you at least establish a record so that future landlords will be on notice that this particular tenant probably is someone they should avoid. Now, here's something that happens very, very often. A tenant will lose in the justice court and then appeal the judgment. Once they appeal, they move out of the premises. If you never follow up with the judgment, it's as if the eviction never occurred, and many, many landlords do not know that this is the case. They believe that because they secured a judgment in the justice court, even though the tenant appealed, that they still have that judgment, but it's simply not true. The moment that a tenant files an appeal and that appeal is perfected, that judgment is gone. It doesn't exist. So if you don't follow the judgment into the appeals court, that judgment is in effect lost. So if your intent was to secure a judgment and put a judgment for eviction on the record of this tenant, or to establish months and months of unpaid rent, even though the tenant has moved out, once that appeal is filed, the judgment is gone. So if you don't follow it up by going to the county court and establishing a new judgment in front of a new court, in effect, by letting the judgment go, there is no record of this tenant's eviction. Additionally, on appeal, sometimes tenants will pay money into the court's registry. And if that money is paid into the court's registry and the tenant vacates the property, but you do not seek a judgment, you may lose out on your ability to collect the money that was paid into the court's registry for rent during the pendency of that appeal. If that's the case with you, follow up the judgment with the county court, get a new judgment, and ask the court at that time for an award of the amounts of rent that are currently being held in the court's registry. The only way that you'll have access to that money is if the court, in fact, signs an order awarding those rent funds to you. If you never show up at the county court and never make that request or file a motion or get a judgment, that money simply stays there in limbo. It belongs to you. It should be in your pocket. But if you never make an effort to accept it or obtain it, the county will simply keep it. Or worse, they'll send it back to the tenant, which is not what you want. If an appeal has been filed and if funds have been paid into the court's registry, I recommend that you follow that matter into the county court, secure a judgment, and secure an award of those funds from the court's registry to you. That rent money is yours. Make sure you get it. If you find yourself in a situation where this has happened and maybe you've got rent funds that are stuck in some registry somewhere and you need assistance with that, don't hesitate to give us a call, set up an appointment. We'd be happy to help you secure those funds and ultimately get those funds delivered to you. If the court has not otherwise forwarded the funds back to the tenant, you may still have access to those funds, and it's important that you get them. If you found this particular video helpful, I hope you give us a like. And if you're interested in watching more content from us at this channel, there's a video here that YouTube seems to believe that you would enjoy. Additionally, if you haven't yet subscribed, there's a picture of me right here. Click on that picture and you can subscribe. I hope to see you next time as we'll continue to deliver new content to help you protect your most valuable assets. Until next time, landlords, happy leasing.